Ghana's decision to receive some 14 West African national deportees from the United States of America have generated public debate in the last few days. The justification from the Foreign Affairs Minister Okudzeto Ablakwa has been that government acted on the advice of the Attorney General, as they believe an agreement between the two countries does not need parliamentary ratification before they execute.
Our decision is grounded purely on humanitarian principle and Pan-African solidarity, to offer temporary refuge where needed, to prevent further human suffering, and to maintain our credibility as a responsible regional actor. Ghana's decision must be understood as an act of Pan-African empathy. It is not transactional. Like Rwanda, Eswatini, Uganda, South Sudan, who are welcoming fellow Africans, we are standing up for our brothers and sisters in distress. And this should not be misconstrued as an endorsement of the immigration policies of the Trump administration.
By speaking to the media in Parliament, the ranking member on the Foreign Affairs Committee, Samuel Abujinapo, said the move by government does not only violate the 1992 Constitution, but also a Supreme Court ruling that demands that all agreements between Ghana and other countries must be ratified by Parliament.
We are also shocked by the Honourable Minister's claim that the Honourable Attorney General advised Cabinet that this agreement does not require parliamentary approval. The Attorney General of the Republic was the Deputy Attorney General when the decision in the Banfor case was delivered by the Supreme Court. He cannot therefore feign ignorance about this case and purport to give a legal opinion which therefore contradicts the decision of the Supreme Court, if indeed he did. The opinion of the United States Attorney General, if it was indeed given, is of no consequence in our country, as both the constitutional provision and the Supreme Court decision are very clear. Indeed, the Supreme Court held in the Banfor case that the distinction in the United States between executive agreements, which does not require the approval of Congress, and treaties, which require such approval, are not applicable in Ghana in the light of the clear constitutional provision in Article 75. The government's conduct in operationalizing the agreement with the United States without parliamentary ratification is a direct constitutional violation of Article 75 and an affront to the authority of the Supreme Court. It is therefore deeply concerning that the government continues to operationalize the agreement with the United States despite these flagrant constitutional breaches. Such conduct reflects a lack of respect for the rule of law, which is one of the fundamental pillars of our constitutional democracy. Ladies and gentlemen of the press, beyond this blatant constitutional breach, the agreement raises pressing concerns of sovereignty, security, and policy. While regional integration remains a core value of our foreign policy, it cannot be stretched to justify the forced deportation of foreign nationals deported from other countries. The ECOWAS Protocol on Free Movement concerns voluntary travel, not forced deportations orchestrated by a non-ECOWAS state. On the international stage, the foreign policy consequences of this agreement are equally alarming. Ghana has over the years built a proud reputation for principled diplomacy rooted in non-alignment, regional solidarity, and respect for human rights. The decision to serve as a receiving point for West African deportees against their wishes with emphasis from the United States risks our country being perceived as aligning itself with the United States government's current immigration enforcement regime, one which has been criticized as harsh and discriminatory. To associate Ghana with such policies could have several negative implications for our country, particularly within the African continent.
The minority is demanding that all such agreements be halted immediately until they are brought to Parliament for ratification.
We therefore reiterate our call on the government to suspend with immediate effect the unconstitutional implementation of this agreement until Parliament has duly exercised its constitutional mandate to scrutinize same and ratify it or otherwise. We further urge government to provide full clarity on the processes, safeguards, and other broader implications associated with receiving these deportees, including the measures, if any, that have been taken to protect Ghana's security interests, Ghana's foreign policy, and the Gaza conflict.